Well, good afternoon and welcome. I'd like to welcome everybody here. My name is Tiger Joyce. Like I know many of you, if not all of you, I'm president of the American Tort Reform Association. We're very pleased to have you here to talk about state consumer protection acts and the need, we believe, to reform them. This is an important project for ATRA. It's really something that we're looking at first and foremost among our key priorities. And one of the ways we're kicking it off is today with a program to talk about the issue, to learn a little bit more, and also to discuss what some potential reforms might be. I'm going to introduce just briefly our moderator, Cary Silverman from Shook, Hardy & Bacon. Cary is the author for the ATR ATRA Foundation. One of the documents that you've received, which is called State Consumer Protection Laws Unhinged. You can see the sort of clever way that's portrayed in the cover. So Cary is a great expert, but we're really pleased to have some leaders in the field, academics and lawyers, to talk about the issue and give us a broad perspective as we begin these efforts. So with that, Cary, let me turn it over to you.
Okay. Thank you, Tiger. It's my pleasure to introduce our distinguished panel today. We have with us Commissioner Joshua Wright of the FTC, Professor Joanna Shepard-Bailey, and Professor Peter Hollend. Commissioner Wright, you can call him a commissioner, a professor, a doctor, or counsel, and you wouldn't be wrong. He holds both a law degree and a PhD in economics from UCLA. And after serving as a law professor at George Mason, he was appointed to the FTC in 2013. Two interesting facts about Commissioner Wright. He actually was an intern at the FTC, where he's now a commissioner during college. And second, after law school, Commissioner Wright served as a clerk for a federal judge that years later presided over the Toyota sudden unintended acceleration litigation that we will likely touch on today. Professor Shepard-Bailey is an associate professor at Emory University School of Law in Atlanta, Georgia. She has a PhD in law and economics, which means that she has an in-depth understanding not only of the rules of law, but also the impact of law and liability on society. She's published extensively on such issues as product liability, tort reform, and judicial selection, and her most recent work is being released today at this event entitled Consumer Protection Acts or Consumer Litigation Acts, a historic and empirical examination of state CPAs, and you should have received a copy when you came in today. And we're happy to have joining us Professor Peter Hollend, who comes to us with the perspective of both a teacher and a practitioner. Since 2009, Professor Hollend has served as the director and clinical instructor of the University of Maryland's Law School's Consumer Protection Clinic. He's been in private practice in Annapolis for about 20 years, starting in a general litigation firm and then opening his own law firm. He represents Maryland consumers in litigation involving auto deal fraud, wrongful repossessions, debt collection harassment, mortgage fraud, and predatory lending. So, about 100 years ago, we're actually celebrating an anniversary this year. It's the 100th anniversary of the Federal Trade Commission. And when I was preparing a law review a few years back, I had the opportunity to read through some of the extensive debate that was associated with, in 1914, of establishing the FTC. And I came across some very interesting comments. A senator from Jefferson City, Missouri, a Democrat, William Stone, rose on the floor of Congress to speak against a proposed amendment. If passed, he predicted, and I quote, "A certain class of lawyers, especially in large communities, will arise to ply the vocation of hunting up and working up such suits. The number of these suits no man can estimate," he said. That amendment that they were discussing was a proposal to add a private right of action to the FTC Act, which would have included treble damages and attorney's fees, similar to what was ultimately passed in the states. Congress rejected that amendment by a 41-18 vote. Now, fast forward 100 years to last week. I was reading, and maybe some of you noticed this article in Bloomberg BNA. It was reporting on a panel that the ABA, American Bar Association, was having that was very much like we're having today. And on the panel was a plaintiff's lawyer, and he was asked why California has seen a surge of consumer class action lawsuits targeting the food industry in recent years. And most of these lawsuits are filed by a handful of law firms, sometimes using the same named plaintiff. Sounds a lot like what Senator Stone was talking about. Was it California's notoriously pro-plaintiff unfair competition law? Was it the judges? No, he said. He said the cases are filed in California because it's a populous state, which means that plaintiffs can add the most people to their class actions, according to Bloomberg BNA. And even this lawyer who filed the lawsuit against Taco Bell that you might remember from about a year ago, saying that its meat didn't qualify as beef, and who that case was withdrawn, and a lawsuit challenging how much more attentive children who eat frosted mini-wheats are, which did lead to a multi-million-dollar settlement, reportedly observed that too many spurious cases have been filed for this upward trend to continue, and suggested that dumb cases aren't doing too well. Well, how did we get to this situation? Are courts properly addressing the dumb cases, or is legislative reform needed? That's what we'll be talking about today. Today, consumer protection is a mix of federal policy making and enforcement, and we're pleased to have with us Commissioner Wright, who will talk about that, state attorney general enforcement and government agency action, and private lawsuits through common law, contract law, and warranty law, and what we're going to focus on today, State Consumer Protection Act lawsuits. Now, originally, consumers had to rely on contract law and tort law, which had significant limitations and challenges. For example, claim for deceit or fraud typically required a consumer to show that the seller knew that a statement was false and intended to deceive a consumer. Even when the law evolved to recognize claims for negligent misrepresentation, the relatively small losses for day-to-day purchases of consumer goods didn't provide enough incentive to go through the time, effort, and money needed to file a lawsuit. Contract law had its own problems. It didn't address situations in which an unscrupulous business made false claims, say an advertisement of a lower price than was actually offered, to entice consumers to come into a store since there was no actual contract entered. And finally, both tort and contract claims provided no way to proactively stop deceptive practices before consumers were harmed. So Congress went ahead and established the FTC in 1914, a 5-member, nonpartisan body appointed by the President with the advice and consent of the Senate to regulate unfair competition initially. It expanded the FTC's jurisdiction in 1938 to move further into the consumer realm. And it kept the terms unfair and deceptive broad, rather than provide a laundry list of deceptive acts, in order to give commissioners flexibility to determine practices that were unfair and prohibit them through adjudication, rulemaking, guidelines, as situations came up. And when originally enacted, members of Congress were concerned that placing such a vague term as unfair in the law could lead to arbitrary enforcement and a lack of notice to businesses as to what types of conduct was permitted and what was prohibited. And these concerns were alleviated by three factors primarily. First, that you'd have a nonpartisan body that would be looking and making sound judgments as to what is unfair and what is deceptive based on their experience in law and business. Second, that the remedies would be primarily injunctive, in other words, stopping a deceptive practice rather than penal, imposing damages, though the FTC would be able to seek reimbursement for consumers. And that resource constraints and public oversight would lead the FTC to focus on actions that are broadly in the public interest. Private right of actions, however, have no such bounds. In the 1960s and 1970s, states passed consumer protection acts, and if not originally, soon after, added private rights of action to them. Why did they do so? Well, they did so as a way of supplementing federal authority, providing for more local enforcement, and also giving consumers a more effective remedy than was available through tort and contract law. But these laws, they vary significantly from state to state. Most don't require consumers to show reliance on deceptive practices. A few do. Some provide for minimum or statutory damages per violation at amounts that range from $25 in places like Massachusetts to $1,500 per violation in D.C. About 2/3 of states provide for treble damages, tripling your damages. And in some states, every consumer who wins is entitled to triple damages, and in others, treble damages are used only when there was a willful or intentional bad act. In nearly every state, unlike in most litigation, consumers are either entitled to recover their attorney's fees or the court has discretion to award them. All but 6 states permit consumer class actions, some that do limit recovery to actual damages, precluding statutory damages. And many states do have provisions that look expressly to the FTC policy for guidance in interpretation, and some exempt conduct that's regulated or authorized by government agencies. The general goal of these provisions is good. It's to provide a sufficient incentive for consumers who are duped into a typical small purchase to sue and protect their rights. And we have an expert panel here today that studied, applied, and enforced consumer protection laws for many years. And no one, to my knowledge, has seriously proposed or considered eliminating private rights of action under state CPAs. Some of the issues that our panel will consider are whether CPAs are being used in ways in which they were not intended, and if so, how. What is the proper balance between the government's protection of consumers through regulations and through enforcement actions and private lawsuits? Are consumers benefiting or are they being harmed by some of these lawsuits? And if there are adverse effects, how do state legislators address the excesses without gutting true and needed consumer protection? And with that, I'll open the discussion to our panel. Perhaps Professor Shepard would like to, or other members of the panel, could begin by discussing what trends you're seeing in consumer litigation today.
Sure, I'll start. Well, we're definitely seeing over the last couple of decades an increase in the cases that are being filed. We only see a small piece of the puzzle. We see the cases that are actually going to trial and what's happening in those cases. What we don't know is how many settlements are being made, perhaps they're extortionary settlements where the threat of going to trial under a CPA claim is enough to induce a defendant to settle to for some amount of money regardless of the quality of the claim. So just in terms of overall numbers, we're definitely seeing large increases in some jurisdictions more than others. Moreover, we're seeing a lot of these cases brought in areas where traditionally other areas of the law have been able to deal with these. So for example, claims that look a lot like a traditional products liability claim. We now see claims brought into the CPA case under a CPA law instead, which is troubling for various reasons, which I'm happy to start the discussion or we can have a broader discussion as well. But it does seem like the use of the CPA law as a tool is kind of expanding into a lot of areas that were not originally intended by the people who originally enacted these laws.
Why would one include a consumer protection claim either as an alternative to a personal injury claim or instead of a personal injury claim?
Well, I think there's lots of reasons. I mean, attorney's fees is a big one, right? Automatic attorney's fees. Every once in a while, a plaintiff will be awarded attorney's fees if the defendant has done something particularly egregious under a normal personal injury or products liability claim, but under a CPA claim, they're generally automatic. So that's a big thing, especially to the extent we think that a lot of attorneys are the ones driving these cases rather than plaintiffs seeking out an attorney. It's often an attorney seeking out a plaintiff, a prospective plaintiff. But in addition, I mean, the things that you have to prove to prevail in a state CPA claim are generally much less than what you would need to prove to prevail in a standard personal injury, tort, or products liability claim. Obviously, there's no need to prove intent like you had to under fraud. You don't even have to prove actual harm under a lot of these claims. So it makes the burden on the plaintiffs and plaintiffs' attorneys much less if they pursue a CPA claim rather than a standard products liability claim. And then, of course, there's the possibility, sometimes automatic, sometimes at the discretion of the court, of trouble damages and whatnot, which just increases the payoff from those claims as well.
In the product liability field, I think an area that I find really interesting is it seems that some of these lawsuits, everyone gets to sue. Either you've got all of the plaintiffs who are actually or claim that they were actually injured by a product will bring their own personal injury suits. They might be individual. If there are enough of them, they'll get consolidated in a mass tort somewhere. But then you'll have plaintiffs' lawyers use state consumer protection acts to sue, and they'll say this in their complaint, to sue on behalf of everyone who did not experience a physical injury for the same exact alleged defect. The damages might be different. Is there anything does that seem right to the panel? Everyone gets to sue if you bought the product, regardless of whether you are actually harmed by a alleged defect?
Right, I mean, the first suit is by the injured parties, and then the second suit is by all the people who weren't injured, but nevertheless bought the product. So if somebody is injured, everybody recovers, right? I mean, that's kind of the goal here, I guess.
And the typical allegation is that while they didn't experience a physical injury, they experienced some sort of economic loss. It could be that had they known of some defect in the product, they wouldn't have bought it. And they want a complete refund of the purchase price, even though they've used it for the last X number of years without any trouble whatsoever. It can be that they think there's a lower resale value to the product, whether it's a car, for example, and they are going to have some difficulty selling it. Or maybe in the case of a pharmaceutical, it could be that they think it was just worth less than they paid for it because there was some potential side effect that they didn't experience, but that might have influenced the price. And we've seen this in a number of different realms. Those are just three examples. Are those true consumer losses that should be recoverable through CPAs?
Well, I mean, in my opinion, they paid a price for a non-defective product, and they got a non-defective product, right? And so somebody else was injured, and we might think that the original price incorporated some risk of some injury, whatever it might be, and that injury didn't happen to these secondary people, the people who were filing the secondary claim. It did happen to other people, but the secondary people got what they paid for. They paid for a non-defective product, and that's essentially what they get. There's all sorts of risks in any product for anything, not just safety risks, but risks that next year the market changes and they would have paid too much, or maybe next year the market changes in a different way and they paid too little. There's so many risks built in that are incorporated in the price, and I mean, the price is composed of so many different variables. It's difficult to say that because it happened to injure one person out of 1,000, far away from this person, that they somehow didn't get what they paid for.
What's the role of, with respect to these suits, we see a lot of them against car companies sometimes, and we kind of are still living through that, but we've seen the Toyota sudden intended acceleration cases, which were very much like what we've described, about 100 or so people filing personal injury suits, and then a bunch of class actions on behalf of everyone else who didn't experience a problem with their cars. And, evidence from some government agencies that seems to clear them of some electronic problems, although several recalls were conducted on things such as the interaction of the floor mats, and also questions about how much driver error was involved in maybe some of these cases. What is the interaction between what our government agencies that are charged with protecting public safety are to do, like NHTSA in this case, which ran a recall program, and what state consumer protection laws ought to do, and how do those interact?
I think you need to look at, you talk about auto recalls. When were these recalls done? I mean, what happens when the regulators fall down on the job? And to say, for the 13 people that died recently that came to light in the General Motors things, I mean, are we going to say that everyone who owns a General Motors car shouldn't be a little worried, maybe want to get their car checked out? Maybe the manufacturer would institute some kind of a recall. And if so, how long was it hidden for, and what were the regulators doing? I would submit that one of the greatest services that private attorney generals, private litigation does is to bring to the attention of regulators who are, understaffed, underpaid, under-resourced. I don't think many people in this room want to see a bigger CFPB and a greater FTC. I mean, people complain about regulation. Well, if we're going to have small regulators, and the legislatures have said, let us place some of this enforcement burden on private people, then aren't they doing their job? The Toyota acceleration cases, I own a Toyota. I was nervous. I wanted it looked at. I read about all these people getting in accidents. I mean, it sounds like a small number until it's one of your family members, right?
Yeah, I mean, I think it's important also to differentiate here between the injured parties and then the non-injured parties who nevertheless bought the product. And, I think even for the injured party, which, obviously nobody would suggest that they shouldn't have some sort of redress. Consumer, we need to look back to the origins of these laws, and they were originally to ensure that consumers who'd suffer some small harm that was difficult to prove would nevertheless see some sort of redress, right? And so there were all sorts of substantive and procedural tools that were built into these laws to circumvent kind of the traditional common law fraud model and the deficiencies we saw with that in terms of consumers being able to recover. But a products liability case is completely different from that original model for which CPAs were designed for that sort of litigation. Small consumer harms, difficult to prove. Products liability cases are typically very large consumer harms. These are not the kinds of harms we need to give people extra incentive to bring the cases. We don't need to give them the possibility of treble damages or attorney's fees, otherwise they may not bring the case. They're going to bring the case because there's been typically a very egregious harm in some way. And so I think that products liability does the job there that it's supposed to be doing, and it's not clear to me why we need a different set of laws that has procedural tools designed for a completely different kind of situation, and now we tack them onto this. And so now, even though there's been already a serious harm and nobody needed incentive to file a case in the first place, nevertheless we give them those incentives with attorney's fees and treble damages and whatnot. And so it's really just providing kind of duplicative incentive effects when we don't need those effects.
I suppose I should say something on behalf of the understaffed, underpaid regulators, other than here. The first thing I should say is that I can't speak on behalf of all of the underpaid, understaffed regulators, and particularly anytime I have a microphone and see people, I have to say the things I say aren't the views of the other commissioners or the commission. That said, the views of one understaffed regular ought to at least be injected. I mean, I think that the broader issue with respect to the interaction between federal regulatory agencies and the states writ large, to include things like the development of state consumer protection law, warrants some discussion. I don't have any particular expertise over the Toyota litigation. I was Judge Selma's clerk and lucky enough to get out of there before that thing hit. So I know a lot more about it. But that said, I mean, I think one of the interesting issues, and I think it goes to the heart of the points that both Peter and Joanna were making, is that one of the things that has happened in the evolution of FTC consumer protection doctrine, and particularly on the unfairness side, when we're not talking about deception, was a move away from the cigarette rule formulation of unfairness into a formulation of unfairness that embedded more directly and explicitly a rigorous weighing of the economic harms and benefits of the conduct at issue. My own view, and I've been a critic of some of the FTC's unfairness cases where I don't think we've taken that requirement quite seriously enough. But as a general rule, I think that requirement has been seen inside the agency as a pro-enforcement development, a way to organize one's thinking about which conduct to target our Unfairness Authority Act, by thinking hard about what the harms are, what harms are real and substantial, and which are not. And sort of for an understaffed agency, I think a particularly important exercise to engage in, to think about where one will allocate their resources. If one's not allocating the agency resources based on where there's the most net harm, I'm pretty sure that agency is doing it wrong. So I think that exercise, one as a resource allocation matter, is an important one. But having it written right into the doctrine, I think, has been an incredibly important discipline within the agency to sort of harness and cabin unfairness in a way that's consistent with the way that the rules were originally articulated and with the design that they had in mind. So for my money, I think one of the most important interactions for the FTC, for example, that it could possibly have with the estates is to engage with the number of states, I think it's well over half, that still follow the cigarette rule formulation, which I think is intentionally unbounded, but unbounded nonetheless. I mean, FTC's view has been for quite some time, and it's been a fairly widely held view, that sort of analysis of the cost and benefits should guide on unfairness. And I think if you've got state statutes swimming around that copy the language of the FTC Act, this is a great place for the commission to interact with the states on multiple levels and have a discussion about whether these formulations in states that have purport to harmonize with FTC interpretations but appear not to, whether closer harmonization would be good for economizing on resources, good for the consumers that both the states and the feds want to protect, and so forth. So for me, I think that's probably, and I know this is sort of, there are many types of Fed-state interactions that we could be talking about. For me, that's a particularly important one to sort of inject into the discussion.
Can I ask you a question? Sure. Does it worry you, though? I mean, so currently, and I guess since about the 80s, this public interest requirement has been understood to be some sort of economic cost-benefit analysis, which I think most people in this room would think is the right way to interpret that. But are you concerned? I guess I'm a little cynical about how that could be misused in the future, and in some, I mean, public interest could probably be defined in different ways. And if we just have this general term in the public interest, well, that's kind of a political judgment in some ways, and depending on the politics of the people making that judgment, I don't know, are you concerned about that?
Sure. I think it's useful for this part of the discussion to distinguish between deception and unfairness. In unfairness, it's baked in. Substantial injury that outweighs the benefits is baked into the elements of the offense. Now, as an economist, you might read that language, and I might read that language as an economist as requiring sort of a rigorous economic analysis that shows the harms are greater than the benefits.
That's why the commissioners disagree with you.
And others, yeah, occasionally I'm in the minority. But at least, so we may read that differently than, say, non-economists. But in the elements of the offense, there's a requirement that there is a demonstration, that the commissioners have reason to believe that the harms are substantially greater than the benefits. Whether one gets there through the same sort of economic analysis that you might do, or I might do, or our economist staff might do, is of course subject to some degree, the whims and fancies of commissioners with votes, and that's right. But we do have inside the agency, and I think this is one of the strong points of the particular agency that I work for. There's a first-rate group of economists that have an independent recommendation on every case. That's not the way that economists are structured in many agencies, including other independent agencies. They work under the lawyers. They, speak when spoken to, and so forth. That's not the way the FTC works, and it's a wonderful thing that that's not the way that the FTC works. And so that part of the building reads that requirement as for an unfairness claim to lie, it must be the case that the economic harms can be shown to substantially outweigh the benefits. I think that provides, no matter who's doing it, some real discipline. Yeah. Reason to be cynical, for sure, but I think that there are some safeguards. On the deception side of the authority, no such requirement baked in. Some economic logic behind the idea that maybe we are safer presuming harm in the world of deception than not. But I think it is a greater worry on that side because the uncertainty now turns to questions like, would the statement, is it a misrepresentation to a significant minority of reasonable consumers and so forth, where I think there's a little bit more uncertainty on the marginal cases, and it's not uncertainty that's bounded by economic analysis, it's bounded by other considerations. And so in my view, that uncertainty is sort of greater than what we'll get in the unfairness cases where you've got that formulation sort of cooked in. May not solve all the problems, but it is certainly a better state of the world, I think, than in the formulations of unfairness that still follow the older sort of cigarette rule that says, no need to do any such accounting.
How do you see, a lot of the state consumer protection acts were modeled after the FTC Act and have similar prohibitions on unfair and deceptive conduct in them, and some of them, as I mentioned earlier, do say we ought to be looking to the FTC for policy guidance and using that to apply in our own state cases to supplement enforcement. Do you see cases, state CPA cases where you look at the outcome and you think, well, that's not the way we would have handled it, or do you think that you would handle some of these cases the same way? And have you seen any cases that you think this really kind of interferes with what our goals are, that it's contrary to what we, from an economic analysis, how this should work out and we see problems with it? Or is it really not something that you're looking at the FTC?
A couple of things that I think are responsive and useful at this point. One, this was something that I studied in my old job as an academic, and sort of holding aside my subjective views about what might satisfy unfairness and not or not. To sort of test the hypothesis that what was going on in the states was different than what might go on under FTC authority. There was a project that I did. It's with Henry Butler, who is now professor at Mason and was previously at Northwestern, that took a random sample of a bunch of real state CPA cases and gave the facts to a set of 5 shadow commissioners who were bipartisan. They were split along the same lines. I think we actually had two Republicans, 2 Democrats, and an independent, former consumer protection directors or commissioners, and asked them, so run the analysis under federal law. And they ended up, I don't have the numbers in front of me, but it was a small fraction of the cases, something in the 20s in terms of percentages, that in these state cases that in their view, majority would satisfy, and of course for unanimous votes, sort of much lower. Most of the business we conduct under the Deception and Unfairness Authority at the Commission are unanimous votes. There are occasional, I've been there 16 months and 4 days if one is counting. But during that time, I think I've dissented from 1 or 2 consumer protection cases. Most of them are unanimous, and if you take unanimous votes and run them on those state CPA cases, it's a much smaller number. Precisely how to decompose that difference is, I think, an important question. How to interpret it is an important question. That there is a serious difference is, I think, at this point, fairly there's now a growing body of evidence, I think, that suggests that there's clearly a difference, and it's probably a sizable one. How sizable is difficult to know. I've done research on the state CPA cases. You know, Joanna's got a great paper looking at this stuff that does, you know, looks at more recent cases than I had. It's hard to know because you're dealing with litigated cases, not settlements, exactly what's under the tip of the iceberg. But the tip sure looks problematic, and at least suggests that there's sort of role for further study. So I'm comfortable with the proposition that what is going on with the states is certainly different than what would be going on at the FTC, and I'm quite sure that some of those differences are systematic. In terms of the role of the FTC, I mean, I think the role, when you've got state statutes that are either modeled after, in some cases encouraged by the FTC, I think the role or even responsibility for the FTC to have an engagement in that discussion is a pretty obvious one. I think it's an area where continued empirical work is really useful to understand what those differences are. If there are benefits from those differences, if there are cases that the states are getting to that are real consumer protection cases where there are benefits, and it's important to understand that. If we're getting over deterrence and getting harms, then it's important to understand that too and have that sort of engagement. I came to the job primarily as an antitrust guy. I spent most of my time thinking about competition problems. There's an analogous situation, to me, analogous with the development of sort of the same structure. You have 50, sometimes more, state antitrust laws overlaying the federal antitrust laws. More than half are modeled after the federal antitrust laws. The FTC had its hand in the crafting of a number of those laws, and many of them have the sort of expected language about harmonizing interpretation of the state law with, say, the Sherman Act. In the 70s and 80s, for predatory pricing claims that a price was too low, drove the competitor out so that the monopolist could raise the price tomorrow to the detriment of consumers, the state law took a sharp turn in terms of the burden a plaintiff would have to satisfy, both to survive summary judgment and ultimately to win at trial. In fact, required no actual proof of consumer harm, just that the price was below cost. At the same time, there was economic learning that said lots of reasons a price might be below cost that are good for consumers for some short period of time. And reasons to be skeptical about predatory pricing claims, let's require proof of harm. The federal law went one way and the state law went another. If you go into the FTC archives of our policy planning office that does our advocacy with the states, it's a big part of what we do on both the consumer protection and competition side. You'll find droves of letters to the states saying, you've got either through legislation or through judicial interpretation this view of predatory pricing law. We think that view is bad for the world and bad for consumers that you are trying to protect, that we are also trying to protect. This is our recommendation to you. Years later, I think many, but not all states have moved closer and closer to federal law, and I don't think that there's any dispute in the antitrust literature among antitrust economists that evolution was good for the world. And I view this problem as similar. There needs to be, I think, more engagement and more empirical understanding of the type of work that we've seen today. More of that to help understand, what sort of reforms, and so forth. But I think that type of engagement is, I think, not only would be good policy for the FTC, but given the particular structure with the harmonization provisions and the hand that the FTC played in the formulation of those rules, I think, to some extent, a responsibility of the agency.
Professor Hollend?
I'd like to push back on a couple of things I've heard, in no particular order, but the empirical shadow FTC study, which I haven't read, but I've read some accounts and summaries. My understanding is that the names of that shadow board are not known, and the cases selected are not known, and that the case summaries that were done are not known. And I fully agree that empirical research is important, but if we're going to, if those assertions are right, and you might tell me they're wrong, but if they're right, I would like to be real careful before we draw, firm factual conclusions, say this is the way it is, if the study is not subject to, being replicated. And
How about this? I'm on camera, and I'll tell you that of the 5, 2 were Democrats that appointed by a Democratic president to be commissioners at the Federal Trade Commission.
right.
2 were Republicans, and 1 was an independent, named as an independent. Part of the reason that they're not disclosed is because they asked not to be.
Right. No, I
purposes of the
understand.
project. And if you ask me, and and I think you're asking me, I can even send you the data.
Okay. Well, okay. So that's like
Deal?
Deal. Okay. A couple other things just I made a note of. As someone who, I am someone who does litigate consumer fraud cases, primarily financial fraud, and I use the Consumer Protection Act. And I think I heard say, that there's automatic attorney's fees in some of these statutes. I'm not aware of any statute that has automatic attorney's fees. What I'm aware of is statutes that say if the plaintiff prevails on a fee-shifting claim, then courts may award reasonable fees. And I can tell you the amount of litigation that goes over, did you prevail on a fee-shifting claim as opposed to a contract or tort claim? And then what is reasonable? That's for a judge to decide. There's full discovery in these things. People ask for all your billing records and stuff. So, and I have seen a lot of fees cut. In other words, there are checks and balances in place, in my view, for checking anyone who is overreaching. Are there people who overreach? Absolutely. And it's a public process. A judge oversees it. So I'm not aware of automatic fees anywhere. And the other thing is, I think I heard something about automatic treble damages. Again, I'm not aware of any statute that has automatic treble damages. Usually it says if it was a knowing violation or willful or there's past, pattern and practice, then, the court may award treble damages. And so again, what I'm hearing is that, this terrible out-of-control system with, lawyers just file these things and these low burdens of proof, and then they get automatic fees and automatic damages. That has not been my experience at all. If we get over the preemption, we get over the forced arbitration, then we can face motion to dismiss, motion for more definite statement, motion for summary judgment, and of course always the Rule 11 sanctions thing if it got that far. So, so I just want to say I have a very different perspective of that there are checks and balances built into the system to weed out frivolous claims.
Well, the data that I've seen, says something a little bit different, and there certainly are quite a number of states where attorneys' fees are discretionary. I know it's a lot of people feel that that represent defendants. If they're in a consumer protection claim and the award is theoretically discretionary, and they lose the case, they feel they're most likely going to have to pay the attorney's fees. But my data shows what we've come across says that about half of the states it is required, and I can list them off, but there's quite a number of them. It's about a 50-50 split from what I've seen. On treble damages, I'm not.
There are some states certainly that
Yeah.
require for a treble damages award for there to be some showing of
Right.
intentional or something like that. But there are some that it is automatic, and so every, like most laws, there are quite a bit of variation in between the states, and so. There are some that definitely have it automatic under the CPA law, not necessarily treble damages in some other area, and also have the mandatory attorney's fees.
I would still think that there would be, in those states where you're saying it's mandatory, there would be a reasonableness factor that a judge has to sign off on it.
Yeah, that certainly could be the case. I mean, and again, you know, I mean, I don't know, I just keep coming back to kind of the origins and the purposes of these laws, and it obviously would make sense when we are talking about a very small consumer harm. In order to induce people to file a meritorious suit that has low economic damages, the attorney's fees make perfect sense. It just, in a lot of these cases, if we're talking about a class action, if we're talking about, you know, a case that could be brought under a products liability claim, we don't have that same need to induce people. There's other protections built in already. In a products liability case, you have a big harm. That's why you file a case. You don't need attorney's fees for the incentive to file the case. In a class action, I mean, you know, for all of their issues, at least they are a tool to bring together consumers with small harms, right? And so it just, you know, the original people who were looking at who were thinking about enacting the CPA laws, they realized there was a problem. There were consumers who were suffering true harms, small harms, but true harms, and it was too difficult for them to recover. And so what they did is they recognized, well, there's these 10 things we could do to make it easier for them, but instead of enacting 2 or 3 of those 10 things, they did all of them. And so it'd be kind of like a doctor who realizes a patient needs a medicine, but instead of giving him 1, let's give him 8.
The real problems seem to arise sometimes when you have these combination of,
that's exactly
remedies, like you're saying, where you have, for example, I mean, treble damages, as you said, are there for these small claims to provide an incentive, but you know, product liability claims doesn't really make a whole lot of sense if there's an actual physical injury and significant damages, or a wrongful death type of claim. Now you're tripling millions of dollars.
Yeah, we see a $2 million damage award and then they automatically triple.
Right, and then you also see it, and the same with attorney's fees. This wasn't some little case. This went on for years and years, and your fees could be, you know, $600,000, and now you're awarding something that's very significant and could have worked perfectly fine under a contingency fee basis. But you also see, you know, some of the most concerning cases tend to be the big consumer class actions. And you know, I guess the question is whether it would seem that the mechanism of a class action, you know, the aggregation of cases, is itself intended to provide a means of giving an incentive to bring small suits. So do we need, in those types of cases, to have treble damages, statutory damages, and attorney's fees? There are about 10 states, I think, maybe it's 6 or somewhere between 6 and 10, where they have class actions, but they say only actual damages. And so they sort of take care of that problem. And there are also about 6 states that say, we're just not going to have class actions, because why do we need them? We have statutory damages and treble damages and attorney's fees. You should be able to bring an individual suit. But then there are the rest of the states where you can kind of aggregate yet have those other pieces. I mean, is that where the problem is happening the most? Do we need the extra incentives, or is it kind of one or the other?
So if I understand, are you saying so on a large aggregated class action thing, you would be okay with a common fund recovery, just not a statutory attorney's fee? Is that
well,
what you're
I mean,
saying?
yeah, I don't want to generalize too much, and I mean, there could be other issues as well, but it is the redundancy that is my primary concern, that if you're going to have treble damages, you don't also need some of these other tools that are meant to give people incentive to bring in claims. If you have statutory minimum damages, maybe you don't need treble damages. If you have a class action, you don't need treble damages, and then attorney's fees on top of that. I mean,
Yeah,
to me, it's the duplicative effects
Right.
of these that is the most concerning.
Right. Because again, I would say just based on my experience, and I think I watch what happens around the country, a lot of large aggregated claims are a common fund recovery. It's a percentage, you know. It's a percentage, and it's not like they're kicking in, you know, another $600,000 on top of it for fees. There's the common fund, and there's your percentage. So a lot of that is going on.
I wanted to get back to an issue that Professor Hollend mentioned earlier, and that's, you know, about the interaction of state agencies protecting consumer safety and private lawsuits, and the frustration sometimes where people feel that agencies haven't done their job in terms of protecting consumers, and so you need to have some backup, some availability of bringing a private right of action. The other side of that coin sometimes seems to be that while sometimes an agency may be too slow to address an issue, they may, I think some experts at agencies might take issue with that and say, well, we couldn't take action because we can only take action when we have the science to support what we're doing. So you've had situations where, cases where, say, the FCC decided they were not going to find that cell phones can cause brain cancer and require people to have headsets, but yet a class action was brought doing just that. You had a class action saying that Teflon was going to give, in everyone's pots and pans, was going to give us all cancer. You didn't see the CPSC issue a recall there. But you had the class action there. And some of these, the first was dismissed on preemption grounds, a rare case where the DC Circuit dismissed on preemption and the Supreme Court did not step in, and the other one was dismissed as well. And so sometimes these cases don't proceed, but there are a number of situations where agencies have decided, sometimes because the science is not there, sometimes because they think more broadly that there could be some other adverse effect. I'm thinking now of the FDA. There was a lawsuit by a group, this is a couple years back. It was kind of an anti-meat group that felt they wanted really stern warnings on milk that talked about the potential, in graphic detail, what lactose intolerance could do to you on every carton of milk. That was not something the FDA would do because they were afraid it would discourage people from giving their kids milk. And there were some lawsuits brought on that. I think that was dismissed on preemption grounds as well. But some of these cases are settled. We're seeing a lot of these suits now in the food realm, whether it is about whether genetically modified ingredients ought to be disclosed, whether the term all natural is being used appropriately, whether cane juice means sugar. And these are still trickling through the courts, with some being dismissed, some continuing on, some being denied class certification. What are thoughts on where that balance is between sort of waiting for the science and considering more broadly public policy versus having a private lawsuit go forward?
Go ahead.
On the balance. Well, I mean, again, it has always been recognized that these private actions under state CPA laws were meant as a supplement to what the federal agencies were able to do. And what they're able to do is limited by their funding or by their need to do a cost-benefit analysis or their need to have existing science at some level before they can move on something. There's different things that can obviously affect their ability. So in theory, obviously the private rights of action do play a role for providing consumers with some protection. On the other hand, I mean, it does look like in a lot of these areas, and you mentioned the food industry especially, that they're almost having like a regulatory effect that goes beyond. It's almost like meeting the federal regulatory standards is kind of the minimum now, because so many different, the threat of lawsuits in different states means that just because you're doing what the FDA says or whatever agency we're looking at is clearly no security that you won't be subject to 50 possible different, obviously more than 50, but in 50 different states, different regulatory claims. So, there's some cases pending before the Supreme Court this year, as we know, which will look at whether or not the federal regulatory agencies, what the preemption issue is there, and may give us some guidance on that, which we can talk more about if you want to. But I do feel like there's kind of a regulatory effect going on with not just the actual lawsuits, but even the threat of the lawsuits. So now, we don't know. The FDA hasn't said, can you say that something with genetically modified ingredients, can you still advertise it as natural? If it meets natural under the FDA's current standard, we don't know, but we do know a lot of food manufacturers are taking that off.
It was real interesting. Earlier this year, I think it was in January, the FDA had been asked by 3 judges who were facing claims in California whether the definition of all natural should include or exclude genetically modified ingredients. If you had something with corn or soy in it, can you say it's all natural because it may possibly have been genetically modified? And the judges took somewhat rare action on primary jurisdiction grounds, which means that there's a federal agency out there that's empowered and charged with doing this kind of thing. They deferred to the agency and said, we're going to put these cases on hold for 6 months, and we're going to ask you as the federal agency to give us some direction as to how we have 100 of these cases. We don't want to get all different kinds of results with this being called all natural there and that not, when they have the same types of ingredients in them in individual lawsuits. Give us some guidance on what to do with this. And just in, I think it was January, the FDA wrote them a response letter back and said, we're really not ready to give an answer. We're figuring it out. We have the actual letter. It's available online. And so the cases are back up and running now. It's been punted back to the courts to make a determination. Should agencies take a more active role in deciding those kinds of issues, especially when they're asked by judges for purposes of uniformity and policy? Or is that really something that just should be decided on a case-by-case, product-by-product base, county-by-county, jury-by-jury, judge-by-judge basis?
I think whenever he says the word agency, that's your cue to answer.
That's why you get paid the big bucks.
Yeah.
So while you were asking the question, I was thinking about an FTC example, which I'll talk about in a second. I mean, obviously, there are trade-offs inherent in the speed of the agency action relative to how far ahead or behind it is of the science that's underlying or the data that's underlying the question. Certainly there are advantages of avoiding the jury-by-jury determination, but an agency can preclude a jury-by-jury determination by shouting out into a room, the answer is 5, but be wrong because the science isn't there and the answer's not 5. So I think there's a trade-off between speed and accuracy that's going to depend on what the underlying science is that we're talking about. And I think that's a fairly delicate balance. The example that I'm thinking of in the FTC experience are made in the USA claims, in which the agency did, had a rule, well before I got there, a decade ago, in which the question was, when are made in the USA claims deceptive? And I think to their credit said, well, goodness, that's an empirical question. It's an empirical question about how those claims are perceived in the context that they're made in the real world, and went out and did real and very good, quite frankly, research on consumer perceptions in response to those sorts of claims relative to sort of a control group, and came up with and formulated a rule. I mean, now it's tricky because unlike questions of some questions of science, in which when we answer them, we have the answer for a while. Other questions of science, I mean, you can go through medical journals and find the opposite results every 10 years. And so, some questions have that flavor, and some questions have, when we know the answer, we know it. Made in the USA claims depend on consumer perceptions, which are fickle and can vary over time. I probably think differently about how truthful a claim is that a product, a consumer electronics product, is made in the USA. If my dishwasher is all made in the USA with US parts, but has a motherboard that's made in China because nobody here makes it, I may not perceive the claim that it's made in the USA as deceptive. It's 99% made in the USA, but other people might. I think these have to be answered empirically when the agencies have the capability of doing that. But I think part of it, the willingness of an agency to respond and get out in front does depend on, the benefits of speed can be substantial. I mean, you're going to be guessing, making your estimates under uncertainty no matter what, even for the science that seems incredibly certain at the time. I mean, I think it's a long way of saying it depends, but I do think it depends, but it depends especially on this trade-off between speed and what the costs are of letting the answer be determined on a state basis, which could be huge in some cases, but the cost of being first as the agency and getting it wrong could be really huge in some cases too. And I think that's just something that agencies have to be sensitive to, informed by people who are on, all of the sides of the relevant issues. But certainly the way that balance would look in the context of Made in the USA claims would look much different than claims about, taking a drug that purports to be a substitute for medicine for a very serious illness, right? Where the consumer, if deceived, is going to not take the medicine and have substantial harm done. You would calibrate those differently, and you should calibrate those differently. So that's a long, it depends.
Mm-hmm. Okay. Well, speaking of some of the percentages, Professor Shepard-Bailey mentioned that the Supreme Court is considering some cases now that might have an impact on consumer protection law going forward. There was just an oral argument that was reported. I heard it on the radio this morning on the way in to work. It's a business-on-business case, but it has significant implications for your general consumer protection case, and that's the Palm Wonderful versus Coca-Cola case. And it's another one where there's this interplay between what an agency does and says is okay and what private lawsuits think is not right. In that case, it's a lawsuit by Palm Wonderful, which makes their own pomegranate juice, against Coca-Cola, which makes Minute Maid and has a blueberry pomegranate juice, which only has a small percentage of blueberry and pomegranate juice, which is about less than 1%. But according to FDA regulations for labeling of juice, it says that this is okay. It doesn't explicitly say anything about percentages. The labeling rules do require, when you look at the ingredients of any product, you're going to see them in order of the predominance, and you can kind of get a sense that these are, since they're at the very bottom, there is a very little amount of these juices in the blend. But the question was whether they can have it prominently in the label, and the Supreme Court seemed extremely skeptical from the oral argument reports. I didn't listen to the entire argument as to whether it would be, it was precluded to have a private cause of action. This is under the Latham Act, but it's very similar in wording to some state consumer protection acts that might mislead consumers into thinking there was more blueberry and pomegranate juice in it than there was. But there also seemed to be some discussion, from what I've heard, of what if those labeling requirements were more stringent? What if the FDA had explicitly said that this is possible, this is the right way to do it? And if they had done that, maybe the outcome will be different. Is it a case by case? Obviously, in preemption law, you're looking at sometimes whether it's impossible to comply with both sets of laws, tort law and or consumer protection law by a state, which has to be trumped by whatever the federal government's law is under the Supremacy Clause. But there are also various policy arguments for why sometimes we would want to defer to what an agency says, even if it's not impossible. It may further the policy, it may further the economic analysis that was done, and the general public interest. How do we balance sort of regulatory compliance with private consumer protection claims? When should things be preclusive, what the federal government says, and when should the door be open to private litigation?
I'd go back to something I said earlier. If you think that the federal regulators are catching everything, That's one thing. The fact is they're not baked into the federal statutes and the state statutes is this private right of action. That is how it is supposed to be. You could look at any number of examples from the financial crisis where belatedly there may be some regulatory action. Most of those started with private actions that uncovered it, that got the evidence out there, that finally, after lots of trying and hemming and hawing, finally got the regulators to do it. So there's an important balance. And unless everybody wants to say, bulk up all of these federal agencies a lot more, which no one in this room wants, we have to have it. We have to have it. It's one thing to talk about food, and you can talk about the D.C. dry cleaner case. I saw that in one of the papers, $56 million. We could talk about that all we want, but the bottom line is what I looked at this ALEC proposal and some of the proposals in Joanna's paper. I mean, the way I read, if you had it the way you want, starting with Tennessee, is you basically would take away, the effect would be to take away the private right of action altogether. When you introduce things like individual reliance and that it has to have this public thing and all of these subjective tests, each one of which will be separately litigated at great expense and great time, and then take away the attorney's fees, you're basically gutting that private portion. And however much you may not like a case or a category of cases, if it's your family member that buys the Ford, Explorer rollovers, or the GM car, or the, God forbid, defective drugs, or the financial products that pretty much caused a global meltdown, it was often in those cases individual and class actions that brought these things to light that, got some measure of belated federal regulation. And so if you want to adopt a system where, in effect, there is no private right of action because there will be no or very limited attorney's fees and the claims will be small, you're just creating, an opportunity for a race to the bottom.
Professor Hollend, correct me if I'm wrong. I don't think the ALEC Model Act suggests taking away attorney's fees. It may suggest that they should be discretionary, which is just what
I'm reading, it says only where the violation was willful with the purpose of deceiving the public. Okay? Having litigated these cases, and this might not be your intent, let me tell you how this is going to come out. Well, you didn't put on any evidence we intended to deceive the public. Yeah, we might have deceived you individually, but this says the public. And then that becomes a whole mini trial. And so there might be some good intentions here, but I'm just telling you from the other side, willful. Okay, do we now have to get into all kinds of discovery of willful? Was there a pattern in practice? When maybe the thing was, I went and bought a used car, you told me it was new, it turned out it was used. Most people would say that was a lie, I should be able to, get my money back or something. But no, this would say, did they deceive the public as opposed to an individual? So those are the things, when I say in effect, that's how I would see this thing developing.
Is there anything else, is there one piece of, say, wherever you saw it, whether it was in the ALEC Model Act or in one of the proposals in any of the ATRA papers that you thought, if that was to go through, that would really hurt consumers? Is there one particular issue that you have
a particular thing
aside from the attorneys?
I mean, I think there's a proposal, as I read it, that only enumerated wrongs. And the problem with enumerating, like all legislation, is we'll enumerate it today, and so then the next scam is tomorrow. So, and it's not enumerated, so it's not forbidden. And so, unless you have a catch-all, you're always going to be behind, and you're not going to be accomplishing, your own goal. I saw a couple of other ones. The class action thing, if I'm understanding it, it says that each class member must have individual reliance. So that means if it's a class of 1,000 people, each one of them has to be brought into court to testify, if I'm understanding it correct, that they individually relied. That's going to kill, the net effect is there won't be a class action.
Are there any reforms that you think would be helpful?
That I liked. I saw some stuff that was of interest. I didn't write those down and underline them like I did the other ones, so I have to get back to you on that.
Okay.
I have
thank
a
you.
couple things to say. On the Tennessee change, they did eliminate, well, they took the private right of action out. They took the catch-all phrase out of the private right of action. So they have an enumerated list. There's private actions are allowed on that enumerated list, but the state AG can still file a claim under this catch-all phrase. So it's not exactly completely eliminating it. It's just saying we have to give some sort of structure here so this thing doesn't get out of control. And I'll mention another thing too. I mean, we're talking a lot about, obviously, the whole point of these laws is consumer protection and protecting consumers. You know, I think there's some debate on how well they're doing that, if they overstep their bounds or whatnot. The one thing we haven't really talked about is that these laws can have real cost to consumers too, right? And so when you were talking about the regulation, and right now people don't know, can they label something as natural or not? The FDA is refusing to weigh in on it for whatever reason, that maybe is good or maybe it's not. But that creates such a sense of uncertainty for sellers and producers. They really have no idea what the law is. They have to be equipped for the possibility of litigation. They do a lot of things to try and prevent that. That increases consumer prices. It also has interesting effects on how much information they are giving. So now there's products out there that a lot of us may actually think are pretty natural, but they're afraid to advertise as natural because they don't know what the law is. So they take that off. That's some amount of information I may like to have that I no longer have. In other areas, we see manufacturers putting so much information on a box so that they can't possibly have been claimed to have not provided some information, that then that information just becomes useless. The more information there is, people just don't even bother reading it. And so it's having all of these perverse effects. The uncertainty is that is harming consumers with higher prices and these weird kind of information distortion effects. And so, I mean, I think that when we're having this conversation and understanding the original goal was certainly consumer protection, there's debate about how well these are achieving those, we need to recognize that they also have the potential to cause real consumer harm as well.
Right. It would seem like, for example, in the Tennessee situation, it's almost a reversion back to the original FTC Act, which was you'd have, yes, we've got these very broad, vague terms, unfair and deceptive, but we're going to feel more comfortable about having those in the law, where we have a state official who is subject to oversight, giving guidance on what those terms mean to both for businesses and for consumers, and doing it in a reasonable way rather than having it done in each kind of lawsuit. Of course, it does, like you say, have significant, perhaps, drawbacks to not allowing certain types of claims before they've been defined, we can discuss whether that is helpful, goes too far in one direction or the other, but I think there's a goal there that makes
and then
sense.
If we could combine that with what Josh was saying about states, fully adopting this public interest as defined by economic cost benefit. So a state AG would have to show something like that before they could, before one of these claims would work. Then we're even a little bit more protected, because now, to the extent there's not an enumerated harm, it's one of these new harms that we hadn't envisioned would occur enough to put on this list, we at least have some sort of protection that the state AG is weighing these costs and benefits, and they're recognizing the harms, but also not having this could also produce some sort of harm as well.
Is there...
I would just add,
sure.
going back to what Josh said earlier, he used the phrase net harm. And so while we may have a wonderful AG in Tennessee, their job really is, I think, to look at what's the biggest harm, where can I have the biggest impact. And so while they're focused on the net harm, all these other things may be going on that no one's going to be picking up, that would be picked up potentially under a private right of action.
But I mean, so long as the net harm is positive, those claims would lie. I mean, I think it's important. I think you overstated a little bit that I mean, I don't know what's in the particular proposals, but the idea that anyone's arguing that the optimal number of private cases is 0, I've never heard anyone, certainly here, argue it or read it. So I think the optimal number is positive, and we're talking about the trade-offs on where to do that. And if one believes that you've oversolved the incentive to bring the claim problem, so let's say, and I think we agree, the issue is you've got cases where the net harm is positive but small, and state AG doesn't do it and the FTC doesn't do it. But those are good cases, right? They're protecting consumers. Consumer welfare goes up when you bring those, right? And those are good cases. And I don't think anybody thinks that those aren't good cases. But the question is, if you've oversolved the incentive to bring those cases,
Right.
do you bring on other stuff that harms consumers? And the body of evidence to which Joanna references, I mean, I don't think that there's, I mean, the discussion we should be having is, you know, accepting those trade-offs, where is the right line? I don't think it's fruitful to talk about 0 versus infinity, because you aren't arguing infinite and they're not arguing 0 with any sort of reasonable charity applied to what people are actually saying. Now, in terms of the body of evidence, I mean, the body of evidence, you know, whether you're not you like my particular study, the body of evidence on the idea that, for example, statutes with vague definitions of consumer protection can lead to higher prices. There's the automobile insurance study, but even taken out of the CPA context, FTC economists, really good ones. Paulina Polito, who unfortunately is retiring from the agency this year, but has been, I think, the best consumer protection economist in the country for a long time, has a great body of work published in American Economic Review and so forth about what has happened as we increase the aggressiveness of going after certain types of food claims. In her example, the collateral consequences of decimating truthful claims about the health benefits of, say, fiber, is one of the papers, just decimated, drove to 0. And these are the types of benefits I think that Joanna was talking about. But just to sort of give a real world example, that is what happened in the agency experience from overextension of the Consumer Protection Authority. And in the FTC, I think this is the way you want agencies to work. They learn from that body of evidence. With a little bit of help and pressure from Congress, they learned from that body of evidence and said, goodness, let's get more rigorous about the way that we're identifying these cases where the net harm is positive. Then let's bring them and bring them with some vigor. And that has been the experience there. I think it's been a positive one. I think it has helped consumers a great deal relative to the status quo. I think that there's substantial evidence of that. And so I think at least acknowledging that those trade-offs are there, and we're talking about what the optimal number is, whether we've oversolved that incentive problem or not, I think that is the right discussion. But I don't think that there's really any doubt that the experience has been, or at least that it is certainly rational to think about harm to consumers that could occur from overextension of consumer protection enforcement. I think whether we're there or not has to be empirically demonstrated. I think we agree about that too. But I think the body of evidence that this is a real concern, I think is fairly well established. I don't think that you'll get any consumer protection economist of any stripe to say that that body of evidence doesn't exist or at least warrant real grappling with. Not that the answer in any particular case is predetermined, but that is a potential cost to be traded off against the benefits of finding those positive net harm claims, I think is the way that the discussion ought to occur and the question around which it ought to be focused.
Let me ask our panelists, and I'll direct this to Professor Shepard-Bailey, but one more question, and then I'd like to open it up for any questions that participants have. Professor Shepard-Bailey, from the work that you've done in putting together the paper and your own experience, is there one, if we can agree that we're seeing excesses out there in consumer protection litigation, is there any one reform or a best reform or something that you think from a legislative perspective can help address and curb that kind of abuse, or is this something that we have to look to through judges or both?
Yeah, so again, I mean, we have 50 different state CPA laws, so what I'll say will be applicable to some and not others, but can I have two?
Sure.
Okay.
Two's good.
So I think, and obviously this is the minority of states where this is even a concern, but there are a lot of states where there doesn't need to be an actual injury for the consumers to be able to bring these claims. And so that would be one thing I would add. And then we wouldn't see, like you were mentioning earlier, the products liability class actions where first the injured parties bring the case, and then then somebody else who without any sort of ascertainable loss. But I think more importantly, I've spoke about this earlier, it's really the duplicative remedies here, these fixes for the traditional common law fraud model. I think that if there are minimum statutory damages, we don't necessarily need treble damages on top of that. Because minimum statutory damages are supposed to be doing their job. We may not need attorney's fees in some of these situations where the damages are high enough. In a class action where there's so many, the whole point of the class action is to bring together consumers with small harms that would not otherwise have an incentive to bring a case, we don't then need treble damages and attorney's fees. And so to me, it's the duplicative nature of a lot of these, in not every state, but certainly in some of the states, that I think is giving rise to so many of the problems.
Okay, well, why don't we open it up for questions? Do we have a mic that we're going to bring around? Okay. Got a few people there.
Can you hear me?
Yep.
Professor Shepherd-Bailey, obviously California and DC are particularly notorious for having these duplicative regulations. What are some other more egregious examples around the states?
Oh gosh, I know aggregate numbers. I mean, I think New Jersey's one of them, right? That has a degree of this. I don't have all of the 50 states memorized. I'll admit that, but there's enough that it is somewhat of a problem, and not everyone maybe has. If there's 9 fixes to this problem, not every state has all 9, but you often see some combination or overlap of them. And it's kind of an interesting legal history how that happened, which is probably not relevant to this discussion, but it's an area. So I guess I can't really answer that question. Probably some other people in this room might be able to answer that better. Maryland, New Jersey, Massachusetts.
There are a number of states that do. Yeah.
You said DC, right?
Mm-hmm.
I apologize if this ground was covered. I had to step out for a moment. But Commissioner Wright, you talked about kind of the history kind of on the antitrust side. But can you talk a little bit about, or maybe expand on your thoughts on why you think the state CPA statutes have devolved the way they did? Like, what was the impetus of where we are now?
A couple of things. So I think my understanding from looking at the changes in the statutes over time, and most of the changes, if you were to sort of line up the individual state statutes and watch changes over time for each of them, a great bulk of the changes happened sort of late 90s to current. There's been a wave. There was sort of a prior wave 10, 12 years before that, but there's been a lot of action late 90s, early 2000s to current. Counting the changes is hard because, of course, if you were to look up on Westlaw and look for statutory amendments, you would undercount by a great deal because many of the changes have been done through judicial interpretation rather than through legislation. This Searle study makes some attempt to decompose these, and it's my understanding that a significant fraction are through, and probably more than an overwhelming majority are through judicial interpretation. Some prominent changes through legislation, and overwhelmingly going in the direction of larger damages, less evidence of actual injury or reliance, vaguer definitions of the substantive violation. Not all of them. There's, California, Prop 64 in the middle of that mix. You have a couple of examples that go the other way. But if you were to count them up, you're talking about hundreds of changes, hundreds of changes, with mostly pointing in one direction, usually clustered over time. And I think largely through judicial interpretation, but not entirely. That, I think, for the Federal Trade Commission's role poses sort of an interesting question about advocacy, which is something we do. Our statutes, Section 6B of the FTC Act, not just allows but mandates us to engage in advocacy efforts to promote our competition and consumer protection missions. We have a large number of staff dedicated to that mission, and I think it is another one of the sort of, sections within the agency who's done sort of wonderful work over time that is largely, almost entirely bipartisan work, and has some combination of lawyers, economists, and policy folks sort of working together. Often what happens is there's proposed legislation that we're asked to respond to, and we must when asked. And so you'll have some effort inside to come up with our view of the existing body of literature, and trying to inform the legislative body on whatever question we've been asked. Is this amendment to the CPA a good or bad idea? Is this amendment to state antitrust law a good or bad idea from a competition or consumer protection perspective? Judicial interpretation obviously poses a little bit of a different challenge, and I think requires a more sort of affirmative engagement by the agency. Of course, serve when called upon, when asked by states, and that's been something that's been common in other areas where judicial interpretation has been a significant part of the change in the law. The predatory pricing example is exactly that type of change. Most of the action was in judicial interpretation. But I think it requires sort of an organizing of resources and activities to identify the issue as important, and to have sort of a real affirmative engagement. For my own personal view on this is the case for agency engagement when you've got state statutes that explicitly, that they make clear that there's supposed to be harmonization or at least guidance from the agencies. I think there's a very strong case to be made that we should have our voices heard on the subject.
One of the interesting areas that I think has mostly happened through judicial interpretation, but it may have in some states occurred by statute, and I wonder if anyone else has observed this, is that the word consumer has kind of been struck from the statutes. I mean, these were consumer protection statutes, but courts are not requiring the person who's suing to actually be a consumer anymore. And I'll give you one example, but I see this all the time. There was this case in Massachusetts where a patron, a college student who was drunk, wandered into the back of the restaurant and somehow fell down a stairway and was killed, and no one saw what happened. No one knows how it happened that he fell down these stairs, but they brought a suit under the Consumer Protection Act as well as a wrongful death claim. And this wasn't a lawsuit about he purchased something from the business and was deceived into buying the beer, which had too much alcohol content, or that he was charged an illegal price for a door entry fee. It was brought under the basis that he fell down some stairs that apparently wasn't up to the building code. And there was no real talk here about, well, what was really the consumption? What was the consuming that was done? There was no purchase discussed at all in the opinion. Addressing that situation, it would seem putting consumer back into these statutes might help address maybe some of the cases that aren't really consumer protection claims, it would seem, but maybe there's a downside that I'm missing. In this particular case, it was, the outcome was that a jury found that the business owner was not negligent, was not responsible for him falling down the stairs. There just wasn't evidence to support it, and found that even if the stairs weren't compliant, it didn't cause his death. But the judge in Massachusetts, which is where this was, they have a law that's a little bit different than most states, where it's a bench trial for your consumer protection claim and not a jury trial. So the judge, after the jury made its finding on the wrongful death claim, ruled under the state's Consumer Protection Act that because the stairway wasn't up the code and was constructed, and this had been decades ago, without a permit, that this business was now liable for the wrongful death damages, plus triple damages and attorney's fees. And the state Supreme Court upheld that, although it found that the measure of damages was wrong and sent it back for a reconsideration. But it gets to the question of, you know, what types of claims should these statutes be addressing, and what should be properly decided through, whether it's wrongful death or personal injury or product liability, and would putting kind of consumer back into it help? And is there a reason why we took that out, or why the courts took that out? Does anyone know the answer to that?
I don't know why it happened. I mean, but again, going back to the origins, there was a hole in the law where consumers weren't recovering for certain harms, and that's why these were created. And a lot of these situations we've been talking about, like what you just talked about, there's another law on point, another claim that could be filed, a standard negligence personal injury claim. And so, I mean, I think a lot of the problem is when there's a claim under the state CPA that they bring along with some other, whether it's a product liability or a personal injury, premises liability, whatever the claim is. That's where a lot of this abuse happens. But I'm not sure when consumer,
Kind of got
other
lost.
than just a general kind of expansion that we saw in you know, the 70s and 80s, really.
Just seems like, shouldn't you have had to have purchased something?
Well, trader
that was the
commerce or
issue
something like that.
in
Right,
litigation, and it just that seems to sometimes not even make its way into these cases.
Right.
Does anyone? Do we have other questions? Do any of our panelists have any final thoughts that they want to share? Okay, well then I want to thank everyone for coming, and I want to especially thank our panelists. Thank you.
Thank you.